There's this deep paradox right at the heart of American law. On one hand, it's been used as this powerful weapon to build systems of racial inequality, but on the other, it's also been the single most essential tool used to tear those very same systems down. Today, we're going to dive into this conflict, exploring how the law has managed to be both the architect of oppression and a hard-fought instrument for liberation.
This quote, wow, it's really the key to understanding everything we're about to talk about. It's the theme we'll keep coming back to, so let's just keep this idea right at the front of our minds as we go.
Okay, so let's really get into this question, right? To find the answer, we have to trace this long, really complicated arc of American legal history and see how the law managed to play both of these roles, a lot of the time at the very same time. Our story starts way back, right at the beginning, in the early colonies. This is where we can see, step by step, how law was deliberately used to build a racial hierarchy, basically from the ground up.
It's kind of wild to think about, right? When the first Africans were brought to Virginia in 1619, their legal status was, well, it was totally unclear. They existed in this gray area, not exactly indentured servants with a contract, but also not legally defined as enslaved people for life. Race-based slavery wasn't a foregone conclusion. It had to be constructed piece by piece.
And this is the crucial point. That ambiguity didn't last. It started to harden into permanent inequality, all through the law. A really pivotal moment was the 1640 case of a man named John Punch, an African servant who escaped alongside two European servants.
I mean, look at this. They all committed the exact same crime, escaping. But their punishments? They couldn't have been more different. While the European servants just got 4 years added to their service, John Punch was sentenced to servitude for the rest of his life. That decision was the first time a colonial court recorded a legal distinction based on race, and it set an absolutely devastating precedent.
And from that one court decision, the system just grew and grew. It wasn't an isolated event. It was like opening the floodgates. Within just a few decades, lawmakers had codified this entire system of permanent, race-based slavery. By 1662, a child's status followed their mother's, making slavery hereditary. Then came laws banning interracial marriage. And by 1705, you have Virginia's comprehensive slave codes, which stripped away all human rights, legally defining people as property.
Okay, so fast forward past the Civil War, and suddenly you see this dramatic reversal. For the first time, the pendulum swings hard in the other direction, and federal law was used to try and dismantle the very system it had spent centuries building.
And the promise of this era, which we call Reconstruction, was truly radical. I mean, we're talking about 3 massive amendments to the Constitution. The 13th abolished slavery, but, and this is a huge but, notice that critical loophole for criminal punishment. The 14th guaranteed citizenship and equal protection, directly rejecting the Dred Scott decision. And the 15th secured the right to vote for Black men. On paper, this was a full-blown legal revolution. But here's the thing. That promise? It turned out to be incredibly fragile, and it was undone with just breathtaking speed. First, a political deal in 1877 pulls federal troops out of the South, which basically ended enforcement. Then the Supreme Court started chipping away at these new rights, all culminating in the 1896 Plessy v. Ferguson decision, which legalized segregation under the now infamous doctrine of separate but equal. Just like that, the revolution was over.
It would take almost another whole century for that pendulum to swing back again. And that brings us to the mid-20th century and the Civil Rights Movement, a period that really was a second legal revolution.
So, what were the activists and lawyers of this era doing? They were basically launching a second Reconstruction. Their goal was to use the law to overturn nearly 100 years of legal precedent that had cemented segregation and discrimination into American life. And their victories, they were just monumental. It was this cascade of landmark laws and court rulings. You had Brown v. Board of Education dismantling school segregation. Then the Civil Rights Act of '64, the Voting Rights Act of '65, and the Fair Housing Act of '68, all outlawed discrimination across vast swaths of American life. Federal law was once again a tool for liberation. But, and this is really the core of our whole story today, even all this monumental progress was built on some seriously shaky ground. That fragility that we saw back during Reconstruction, it was still there.
So even in these moments of incredible triumph,
The laws themselves were often the result of messy political compromises. They were passed with underfunded enforcement agencies and, in some really key cases, with temporary provisions, basically expiration dates, that required Congress to reauthorize them over and over again. Just look at the Voting Rights Act, for example. It's often called the crown jewel of the civil rights movement, but here's the catch. It was never made permanent. It was designed to be a temporary shield that had to be renewed by Congress again and again for 5 decades. And because it was temporary, it was vulnerable. And in 2013, in the case Shelby County v. Holder, the Supreme Court essentially gutted the law's most powerful enforcement tool. The court's reasoning, which you can see in this quote from Chief Justice Roberts, was that the formula used to figure out which states needed federal oversight was outdated, because, in his words, our country has changed. And the fallout was immediate. I mean, literally, as soon as that ruling came down, states that had previously been covered by the law began passing a whole wave of new restrictive voting laws. Things like strict ID requirements and closing polling places, especially in minority communities. The shield had been lowered. So all of this, it brings us right back to the central argument of this explainer, this fundamental asymmetry in how American law has been applied to the issue of race. When you really step back and look at the big picture, the asymmetry is just stark. On one side, you have the laws of oppression, the slave codes, Jim Crow. They were designed to be permanent, they were fiercely enforced, and they proved to be incredibly durable. And on the other side, well, the laws of liberation have so often been temporary, weakly enforced, and highly vulnerable to being reversed. And that is exactly why we started with that quote. It isn't just a clever phrase, it's a painfully accurate description of this legal history. The laws that took rights away were carved in stone. The laws that granted them were written in pencil, all too easy to erase. So we end on this question, which really points to the unfinished battle. The story of American law shows us that it has this immense power to create and sustain a racial hierarchy. And it just begs the question that our source material leaves us wrestling with. Why hasn't that same power been used with the same permanence and the same force to finally and fully eradicate it?